got a quarter.
Due to the graphic nature of the following program, viewer discretion is advised.
My client comes to you in a wheelchair. My client is also blind. Your Honor, we wish to have a hearing.
March 6th, Your Honor.
March 6th it is.
Judge, I understand the rating on the PSA, but I don't think he'll do well in the jail waiting for his hearing. Your Honor, would you please consider a personal bond?
Your Honor, this will object to a personal bond. This is a multi-state offender. He has convictions in Wichita, Kansas, and Ohio. He has an open disorderly conduct, criminal history for aggravated escape, attempted escape. This attempted escape in Kansas. He also has convictions for prep for sale and possession. In this case, it was reported that the officers responded to a tavern in connection to a patron verbally threatening other patrons. The defendant was observed throwing a handgun in a garbage can when the police arrived.
Your Honor, I know the numbers are serious, but on the PSA, but some of these cases are from 2001, 2002, about the felonies, 1993. Your Honor, I'm hopeful that you will consider his physical condition when giving a bond.
The escape is from 1993. And it says that they don't even know what the disposition of that case was. It is a concern of the court, his physical conditions, and according to your probable cause, no one was harmed. Is that correct?
That's correct.
Personal bond.
Judge, thank you.
Thank you, Your Honor.
You come back to court and stay out of trouble.
Ma'am.
Don't thank
Yes,
me.
Ma'am. Yes, ma'am.
Judge, I'm advising my client not to speak, but in any event, we're entering a not guilty plea. And he's going to address the court if you allow.
My suggestion to you, sir, is to listen to the advice of your lawyer. That's why she's standing there. Now, if you want to persist and think that you know better than she does about what to do, I will certainly listen.
I don't think I know better, but I just wanted to say something.
Well, if you don't know better, then you should listen.
I know.
5 on a criminal scale, 4 on a failure to appear scale. Mr. Prosecutor, anything from you?
Yes, Your Honor. We'd like the court to also take into consideration that he was just arraigned on a similar charge on February 5th, and it appears that he has not learned his lesson as far as that's concerned. And the court also has access to his other convictions.
Is he on CSR? Probably not.
Judge, he still wishes to talk.
I'm listening.
Go ahead. Go ahead.
Yeah, I was here before. But I knew this situation was a whole totally different situation. And it was to my understanding that when the mother contacted me.
Sir, I am not going to listen to the facts of your case.
You're not-
It is not in your best interest,
You haven't
and I'm not
tried.
going to let you waive the rights
Okay.
that you should be listening to your attorney about.
Okay.
$75,000 bond. no contact CSR if it's not in place.
Domestic violence, criminal damages. You also have a drug use marijuana that goes back to Judge Carr. Judge Carr put a bond of $10,000.
Your Honor, she's entering a plea of not guilty. Judge, she would also like you to visually observe that her hand is wrapped. There may have been mutual combat, if you would consider that regarding the bond.
Mr. Prosecutor?
Your Honor, just note that there is already a bond on there and would defer to the court as a bond to this matter.
Judge, she's attempting to sign the no contact order, but the hand that she writes with.
Any mark substitutes a signature, so that's not a problem.
So she has managed. I just want you-
$7,500, CSR, GPS, no contact. No contact means just that, ma'am. Do you understand?
Yes.
You could end up in my courtroom. In my courtroom, if you violate the no contact order, you go to jail for 30 days for contempt, regardless of what happens to this case. Are you hearing me?
Ma'am, good morning. My name is John Cuddick. I'm a prosecutor of the city of Cleveland. You are here on your motion for a temporary protection order in front of the judge. Is that right? Yes. Could you please state your name and spell your last name and speak up so the judge can hear you?
Jasmine Rice.
Spell your last name, please.
Price.
Do you know the defendant in this case, Kellen Hardnick?
Yes, I do.
How do you know her?
She is the mother of my boyfriend's youngest son.
Did something happen between the two of you on February 15th of this year that brings you here today?
Yes.
Could you briefly indicate what happened?
So I was at my boyfriend's house, laying in bed. He was playing a game. She came over, supposedly just to drop his son off, but she ended up coming in the house. She had a little disagreement with him as far as why he wasn't answering the phone, and then she left out. We thought she actually had physically left the house, but she came back into the room, said something else to him, and then she hauled off and just hit me while I was laying in bed. And he grabbed her and got her out the house.
Does your boyfriend live in the city of Cleveland?
Yes,
Okay. Where exactly were you hit?
in my left eye.
Okay, were you struck with an open hand or a closed fist?
A closed fist with a ring.
Did you seek medical attention?
Yes, I did.
Where did you go?
I went to urgent care on Mayfield Road.
Okay. It appears you may still have visible injuries. Can the court take note of that, please? On
Can you
your
show
left,
me where the injuries are?
Here.
on the
Okay.
left is swelling, I believe. A little bit.
Swelling mark on the left eye and the bridge of her nose.
Thank you. Has the defendant ever struck or assaulted you in the past?
No.
Do you fear for your life or that physical harm will be done to you?
Yes.
Your Honor, at this time, the City of Cleveland respectfully requests that she be granted her motion for a temporary protection order ex parte.
Motion's granted.
So would you step forward and raise your right hand? Do you something swear the testimony about the given statement and the truth, the whole truth, and nothing but the truth, as you should answer unto God, so I do.
Yes, sir, I do.
Which has been sworn, time is 9:52.
Mr. Cuddy?
Thank you, Your Honor. Sir, again, my name is John Cudnick. I'm a prosecutor for the City of Cleveland. You are here on your motion for a temporary protection order. Is that correct?
Yes, I am.
Could you please state your name, spell your last name for the record, and speak up so the judge can hear you?
Daryl Jones, Jones.
How do you know the defendant in this case, Ronald Reed?
We work together, same place.
Is that workplace in the City of Cleveland?
No, it's in Solon.
Okay. Did something happen between the two of you on February 17th of this year?
Yes, it did, sir.
Where did this incident take place?
At Mr. Reed's residence,
Where is his residence?
149th and Kinsman.
Is that in the City of Cleveland?
Yes, it is.
Could you please tell the judge briefly what happened that brings you here today?
Okay, that morning, Mr. Reed had called and asked me what I had, plans for the day. I told him I wasn't sure. I'd get back with him. He informed me when he got back from Chardon that, he would call me, and I told him I would come over. And by this time, I'm on the other line with another co-worker of mine, and me and him were discussing Mr. Reed, like we always do, because every other weekend he goes to Chardon. He has a girlfriend in Chardon, and he also has a girlfriend down the street from
Okay,
where.
let's not get into his
Right.
personal business.
That's how I got this, ma'am.
Okay, but I
well,
don't
yeah,
need to know that kind of detail.
Okay.
Did you go and meet with him at his
Yes, I
residence?
did. Yes, I did.
What happened?
When I got over there, we were just sitting there, run off at the mouth, and his phone rang, and he went in the kitchen, and he came back from the kitchen and reached over the table and just busted me straight in my eye.
Okay.
Just like that.
Did he use a closed fist or an open hand?
Oh, it was closed fist, sir.
How many times did he hit you?
Twice.
Okay. Did you seek medical attention?
Yes, I did.
Where did you go?
I went to Southport and I had the paperwork.
Okay. It appears you still have a visible injury. Could you show that? Can the judge, if the judge can see the swelling on the left side of his face?
All right, so sir, the injury indicates a swollen left eye, is that correct?
Yes, it is.
It's also discolored a bit?
Yes.
All right.
Has he ever done this in the past?
No, we've never had a problem before, sir.
Do you fear for your life or that physical harm will be done?
Yes, I do.
Your Honor, at this time, City of Cleveland respectfully requests that he be granted his motion for a temporary protection order ex parte.
Your motion is granted.
Thank you, ma'am.
Yes, Your Honor. Ms. Jones is waiving the preliminary hearing. Her record indicates that the only thing there is a license required to operate from 2015. Other than that, no felonies, violent convictions, no CRB misdemeanors. My client, she takes care of her disabled children, one of whom has autism. She also does volunteer work at both the school district and the church. We'd request a personal bond.
Has she seen her probable cause?
She has a copy of the
it?
cause,
Okay.
yes.
Mr. Prosecutor?
We'll defer to the court, Your Honor.
All right. Personal bond. Put my trust in you. Okay? All right. All right, folks. We've been talking a lot about bond and et cetera. Now, all the comments you're hearing at this point are not determinative of anybody's guilt. In fact, just like R. Kelly, you are presumed innocent regardless of what anybody says. Everybody understand that? You understand that? Okay, all right. So while we put it, bonds and probable cause statements are all preliminary matters. They're not an indication of whether you have done or committed the crimes that you have been charged with. I started to play I Believe I Can Fly, but I figured you all got the message, right? All right.
With regards to bond, my client is retired, so he's on Social Security right now. He formerly did landscaping work, and he still occasionally takes this occasional side job here and there. Regarding his record, Your Honor, while he does have criminal trespass from 2018, the bulk of the prior record dates back to 2012 and older. So for the past approximately 7 years or so, my client hasn't had any sort of violent offenses or felony offenses of that nature. And certainly no prior failures to appear within the past 2 years. The only older failures to appear are on criminal trespass and a disorderly conduct ticket. So with that in mind, Your Honor, we request either a personal bond with whatever release conditions or alternative amounts the court might determine appropriate, or in the alternative, Your Honor, we would request a low cash bond that my client would be able to post.
Mr. Prosecutor.
Thank you, Your Honor. The state will ask first for a no contact order and also at least a $40,000 bond in this case. The defendant is not only a multi-county offender, but he's a multi-state offender. He has convictions in Ohio and North Carolina. And in Ohio, he has convictions from Toledo, Sandusky, Ottawa County, Cuyahoga County. He appears to have open cases from 2010 in Toledo. So I assume that he has been CAPIA since 2010 for those cases. He has a 2018 case from Sandusky for criminal trespass and disorderly conduct. 2017 Ottawa for DUI. Has 2 felony convictions for domestic violence in 2012, 2011. Disorderly conduct before that, and in 2003, multiple convictions from North Carolina for DUI, similar to DUI, assault, and communication threats. Now, in this case, The victim is the defendant's ex-girlfriend, and it was reported that when the officers arrived to the scene, they saw her bleeding from inside her ear, and the victim reported that there was an argument. At one point, the defendant grabbed her by the neck and threatened to kill her and say that no one will stop him. He also punched her multiple times in the head.
Okay. In response, Mr. Attorney Sweeney?
Your Honor, first and foremost, we would, of course, deny the allegations. Secondly, I would note that the pending charges that the prosecutor mentioned from Toledo are disorderly conduct tickets that my client believed he had resolved. Those aren't open like DUI cases or assault cases or anything of that nature. They're disorderly conduct tickets. The more recent criminal history that the prosecutor mentioned are disorderly conducts, criminal trespass. Well, there is a DUI from 2017. The violent history and the felony history that the prosecutor mentioned is significantly older. So still with that in mind, we would request still either a low cash bond amount or a personal bond with whatever release conditions the court might determine appropriate.
All right, I'm going to accept and grant your request for a low cash bond. $10,000 would be the bond set with court supervised release.
How much, Your Honor?
$10,000.
This state will object, Your Honor.
And court supervised release. There's a no contact order signed and executed by the parties. You know what that no contact order means? It's clear?
Yes, sir.
Now, on this entry, I'm going to indicate that violation of the CSR may result in your bond being revoked and doubling. I'm reading the probable cause, Mr. Prosecutor and Mr. Attorney Sweeney. It says that Mr. Lotman used his hands and fists and physically fought with. And the key word here is fought with as opposed to attacked. So I saw the word fought with. Violation of CSR. All right. So we're trusting that if you make your bond, that you will comply with all the terms of the no contact order. Good morning, Mr. Thomas. How are you today?
Blessed by the best, son.
All right, Mr. Sweeney.
Yes, Your Honor, my client is waiving the preliminary hearing. With regards to bond, my client is a contractor. He's self-employed. He actually has an active contract right now at a nail salon on Denison. He also volunteers passing out food. With respect to his history, Your Honor, I would note that there's only one prior violent conviction on his record that's more than 20 years old. He does have a more recent attempted weapons under disability charge from 2015, but in terms of violent offenses, Your Honor, the only offense there is significantly older. So with regards to bond, Your Honor, since my client is self-employed as a contractor with an active contract, we would request a personal bond with whatever release conditions the court might determine appropriate.
Mr. Prosecutor.
Thank you, Your Honor. The state will ask the court to consider the defendant's criminal history. He has a federal conviction for bank fraud, as well as trafficking and multiple gun-related convictions, the most recent one from 2015.
All right, personal bond granted in this matter. Okay.
Will object, Your Honor.
Objections noted. You saw a copy of your probable cause statement?
That's this, sir?
Yes.
Yes, sir.
Mr. Public Defender?
Yes, Your Honor, I would note, as it relates to bond, my client works for a moving company, and he's also a musician as well. With respect to his record, Your Honor, while he does have one prior violent conviction for aggravated robbery, I would note that was October 2008, so that's more than 10 years old. So So, Your Honor, with respect to bond, we would request personal bond with whatever release conditions the court might determine appropriate. He does rank a 3 and a 2 on the public safety assessment.
It is true, this assessment is low. Mr. Prosecutor.
It may be so, Your Honor. However, there's some information missing from the risk assessment. I will say that the defendant has at least a 14-year-old history with guns. In 2006, he was either found delinquent or convicted in Memphis for carrying a gun into school property. Then we have in 2008 a conviction for having a weapon under disability. In 2008, another conviction for aggravated robbery, and last year, a conviction for attempted carrying a concealed weapon. In this case, it was reported that the defendant and an accomplice committed a robbery at gunpoint.
Your Honor, if I could just respond to that. Several of those older convictions, as the court is likely aware from the public safety assessment, don't appear on the public safety assessment. To the extent that one or both of those are juvenile convictions, we would object to considering any sort of a juvenile record as part of setting bond. We would still maintain that the risk assessment, as set out in the public safety assessment here today, is still a lower risk assessment, a 3 and a 2. We would request either a personal bond with adequate release conditions, or in the alternative, a low cash bond amount that my client could make.
We'll object to a personal bond.
You did, everybody did read the probable cause statement, right? Okay, all right. There is a no contact order signed and executed. Bond is $35,000. Should the defendant make bond, supervised release is appropriate. There is his assessment is relatively low. You've seen a copy of your probable cause statement? You have a copy?
He has a copy of it.
Okay. All right. And your hearing date is 4/5/19. Okay. What kind of instrument you play?
I'm an artist.
The artist?
Yeah.
Oh, okay. I'm trying to play the bass, man. I'm in my 5th lesson. You know that? Right. I'll be ready. I'm gonna play Jimi Hendrix for us all over. Mr. Public Defender?
Yes, Your Honor. As it relates to bond, my client is employed. He works landscaping and snow plowing for his uncle. He does that full time. He has, as you can see from the public safety assessment, no prior record whatsoever. Additionally, based on the probable cause, I would note that based on my reading of the probable cause, it appears that the reference to the handgun is to the juvenile that he was with. So with that in mind, Your Honor, we would respectfully request a personal bond with whatever release conditions the court might determine appropriate.
Mr. Prosecutor, are there any co-defendants that you're aware of?
Your Honor, the state will ask for at least a $50,000 bond in this case, in response to the defense counsel's statement that the defendant has no prior record whatsoever. I will disagree. Start by arguing that he just turned 18. He was prosecuted last year in juvenile for aggravated burglary, and he failed to appear for the disposition of that case, and he's been a fugitive since that date. Now, that case was in regards to an aggravated burglary as well, where it was reported that he broke into the house of his girlfriend's old boyfriend, ex-boyfriend. He chased people inside the house and started shouting, "I have a gun. Whoever comes here, I'm going to shoot." He slapped the victim across and then the face and then fled the scene. He also was failed to appear for the disposition on an aggravated menacing, where he was threatening his mother that he was going to come over, he was going to bust the window, shoot the house up, kill other people, shoot them, set the house on fire. In regards to other people, he said that he was on his way that in regards to one particular person, that she cannot leave him, and that she can only leave him if he takes her out, and that he was going to go through her bedroom window, drag her out, kill her, bury her in her backyard. He also has a prior incident with his mother, where he went after her, tried to hit her 4 times. People held him back, and at one point he threw a phone at her because he was calling 911. As he was able, from the disposition in the 2 cases, aggravated menacing and aggravated burglary, he picked up this new case.
Your Honor, if I could be heard.
In fact, we're going to sidebar for a moment. All right, we're back on the record.
And Your Honor, just to respond to the prosecutor's statements, we would, of course, object to the any reference to juvenile record, juvenile proceedings in court for the determination of bond in an adult charge. So we would object to any reference to that on the record today. And we would request a lower cash bond amount in this case.
All right.
Right here, Your Honor.
You may be.
In response, in this case, it's very relevant because it demonstrates that he's a high flight risk because he is capious from a disposition in a case. He's been capious for months in regards to that case.
All right. Thank you, gentlemen. You've argued very, very effectively. I'm going to set the bond at $30,000. He has demanded, so we can't do anything in terms of court supervised release at this point. We'll see what happens at this hearing. All right.
For a videotape copy of this episode, call 664-3571 with the following information on your TV screen.